Good morning, landlords. Hi, I am Ernie Garcia, landlord attorney. For those who've been waiting for the live stream to begin, we apologize for some technical difficulties that we were having, but we are good to go and are excited to talk about when an attorney is even needed. Why the heck would you come and see an attorney if it's not absolutely required? We want to make sure we answer all of your questions. If you've got a question, make sure you add it onto the live chat. We look forward to communicating with you and are happy to answer as many questions as we can while we are here live. But the big question, what does state law say about when an attorney is needed? And I know that our audience stretches beyond the state of Texas, and so I can't speak to specifically, what the rules are in every other state. So when it comes to state law, I'm going to limit that talk specifically to the state of Texas. But as a general matter, generally speaking, an attorney is not needed when you are filing an eviction. So filing the eviction is not something that's going to require an attorney necessarily, nor is presenting a case at trial generally. But when is it good to consult an attorney? Well, definitely if you've never done an eviction before, even if you have the right to file for an eviction on yourself, it might be a good idea to at least talk to someone to get a little bit of guidance. So is it 100% necessary? Could you wing it? Absolutely. Do landlords go and just figure it out as they, kind of walk through the process? Sure. And do those landlords win cases? Yes, they do. But I've seen so many landlords just try to figure it out as they go, and they get turned away and turned away and turned away by courts because they keep making small procedural errors, especially if you live in a state that leans more heavily toward the tenant. You've probably got more hoops to get through than you might maybe in a state like Texas. But even in Texas, even in a state where the rules and procedures and the laws really lean more heavily in favor of landlords, there are still things that landlords need to get right if they expect to win their eviction cases. And so I want to talk about the specifics in the state of Texas, which again might apply more broadly through other states, but I'm not going to speak to the laws in other states and how that necessarily works. And then we'll get to your question. So what does the law say about non-attorney representation? Well, one of the good things for landlords is that in Texas, definitely, and across the U.S. and many other states, non-attorney representation is perfectly legal, especially if the property is in your own personal name and your name is the listed landlord in your lease. There's no reason why an individual cannot step into a court and ask the court for some kind of redress. It's a constitutionally protected right that we get to petition our courts for assistance when things go wrong, in this case, in the civil realm. And so if you've got an eviction and you've got a lease written in your name for property that you own, no problem, 100% of the time, you can walk into court and take that case all the way up to the Supreme Court because you are the only party involved. Well, where do things get complicated? Well, they'll get complicated if, for example, you are there on behalf of someone else. And whenever you are representing someone else, the courts tend to favor that representation being from an attorney. But in the eviction court, there is a caveat. And so I want to read out of chapter 24 of the Texas Property Code, a chapter that we refer to a lot because that's where in Texas we understand what service of a notice to vacate is all about, along with other rules having to do with evictions. But in chapter 24, subsection 011, it reads, in eviction suits in justice court for non-payment of rent or holding over beyond a rental term, the parties may represent themselves or be represented by their authorized agents who need not be attorneys. So let's understand what this section of the code says. It's got to be for non-payment of rent or holdover. In this case, if you're going to have an authorized agent representing you, then it can't be about some non-rent lease violation. If that's the case, it better be you or an attorney. So here we're talking about non-lawyer representation. In other words, someone who's standing in for another party. Let me give you an example. Let's say that you have rent property and you have your cousin who, say, is a realtor or some other real estate professional, and they are managing the property for you. This person can stand in any case in the state of Texas, in the Justice of the Peace, where all evictions start, in any case, and represent you in a non-payment of rent matter or in a matter involving holdover. And for those of you who are unfamiliar with the term, holdover has to do with the termination of a lease and someone staying beyond that date. The lease was supposed to end, say, on September 30th, but they've stayed into the month of October. That person can be issued a notice to vacate on the basis of holdover, and that case can be presented to the court by an agent, an authorized agent of the landlord. So it doesn't have to be the actual owner. Their agent can show up. In any eviction suit in justice court, an authorized agent requesting or obtaining a default judgment need not be an attorney. So if you show up and it turns out, ooh, I'm here on a non-rent basis, am I allowed to present this case? Well, if it turns out that the defendant doesn't show up and you are winning the case by default, then there's no harm. You can, even as an authorized agent of a party in a non-rent or non-holdover case, perfectly fine. This says any eviction that's out there, an authorized agent can go in and take care of the job. So let's understand, if you're in justice court, which is the initial trial court where all evictions are filed in the state of Texas, if you're an authorized agent, you can represent any landlord for any kind of eviction as long as there is a default judgment. If the tenant doesn't show up, you can present any kind of case. However, if the tenant shows up, the only time that an authorized agent who is not an attorney can present that case is if it's for non-payment of rent or holdover, any other kind of eviction. And the JP can say, I'm sorry, that's the unauthorized practice of law, and you really either need to bring the owner in or an attorney on behalf of the owner. So, if you're asking me, is that common? This is the most common kind of eviction, non-payment rent or holdover. And so because that covers most of them, most of the time you're going to be covered pretty well. The real question comes in the appeal process. Are the rules different for an appeal in Texas? And I wouldn't be making this video unless they were. And so I want to explain what the rules say once an appeal has been filed and you're leaving the justice court and going to the higher court, which in Texas is the county court. So if you're going from the original trial court in eviction to an appeal setting, what is that difference? I want to talk about that now, and the code references it. So the code goes on to say, in an appeal of an eviction suit for non-payment of rent in a county or district court, an owner of a multi-family residential property may be represented by the owner's authorized agent who need not be an attorney. So let's just stop there because there's another part to that. So this is very much more narrow than the previous. So now that we're on appeal, this limits it specifically to an eviction suit for non-payment. It doesn't allow it for holdover. It doesn't allow it for matters having to do with non-rent lease violations, right? So it's got to be for non-payment of rent, and it's limited to a multifamily residential property. So this wouldn't apply to a commercial lease. So you've got a multifamily residential property, specifically for non-payment of rent, they may be represented by the owner's authorized agent, the property manager, that cousin real estate agent. In this situation, it's a situation where you've got non-payment of rent for a multifamily unit. Typically, it's the manager or the assistant manager who works at the front office for the apartment complex. This is carved out specifically so that that individual can present their case at the eviction appeal. Non-payment of rent, multifamily, residential. But it goes on. Or if the owner is a corporation or other entity, again, another difference. So the first is an individual who owns an apartment and sends their authorized agent. Now, if it's an owner that's a corporation, an LLC, a limited partnership, they can be represented by an employee, an owner, an officer, or a partner of the entity that doesn't need to be an attorney. So remember, if it's an individual who owns an apartment complex, their authorized agent can go, but it's got to be multifamily, it's got to be residential, and it's got to be for non-payment of rent. In the event that you've got a multifamily unit, an apartment complex owned by a corporation or other registered entity, then you're limited to an employee, an owner, an officer, or a partner. And so if you don't have one of those people showing up, you can't just have an authorized agent. Well, what are they getting at specifically here? Well, one thing that's become popular in evictions is are these eviction services that people can hire to present cases, because as we saw, when it's for non-payment of rent or for holdover, an authorized agent can go and present the whole case. There are eviction companies out there that go who are not attorneys and can present cases. That's true. Their level of expertise, by the way, varies widely. But they're not allowed to present a client on an eviction appeal. So certainly if you've gotten to the appeal level, you're limited to who can present that case. It's got to be about non-payment of rent, and it's got to be for a residential unit, and it's got to be for a multifamily unit. If we're talking about a single family home, doesn't apply. And so if a single family home is owned by a corporation or some other registered entity, you must have an attorney represent you if you're planning to win your judgment on appeal. Otherwise, if you've got an LLC or a limited partnership or a corporation that owns a home, you better be sending an employee of the corporation, the LLC or that partnership, the owner, an officer, or a partner. You can't just send an eviction company to come and carry the load for an eviction appeal. Listen, if all of these rules blow your head right off your shoulders, again, you're always going to want to consult an expert, someone who is familiar with the law, someone who understands the law as it is written, and that's why we're here to help. And so if you've got questions, and I know you do because they're coming on my desk, if you've got questions, we're happy to answer them. And I look forward to answering those questions, particularly about attorney representation. But whatever you got, I'm here. I'm going to answer those questions, and I'm going to get started in just a second. But certainly if you are in Texas and you have an eviction question and you're interested in hiring an attorney, we're always here for that. But there are some of you, many of you, by the way, who are interested in doing this on your own. This is why we're having this conversation, because many of you are all about the do it yourself. I'm going to handle it. I know that I own this property, or I'm an employee of the owner of this property, or I'm an officer of this entity that owns this property, and I'm going to handle these evictions. But you need just a little more oomph. You need a little more in your toolkit to make sure you can do that. We've got an eviction course that you may have heard me talk about in the past. If you go to attorneyeg.com/EV, you can see all about the eviction course that we have for the state of Texas. I walk you through the notice process, the filing process, trial, and appeal. If you're interested in learning more about how you, on your own, can follow this law and walk into an eviction court successfully, I strongly encourage you to check out attorneyeg.com/EV. If you can't remember that, that's okay, because that link is in the description below. We'll put it in the comments to make sure that you have access to it at all times. Let's get to those questions. First one, not exactly on point, but I'm going to answer it anyway because it is an important one. It says, my spouse does the repairs on our unit after a tenant leaves. Can I put a clause in the lease that charges what is expected to be deducted from a deposit if they don't leave the home clean or if they leave damaged? Example, $500 to make the unit ready, $25 for trash, $150 for a dumpster rental. So yes, in a word, you can do this, but I would be very careful not to make it so ambiguous that it becomes unenforceable. So a couple of things that I recommend to landlords all the time in your house rules as an addendum or even as a special provision in your lease to mention that you and the tenant agree that if you're going to step in at any time during the term or after to cover some obligation of the tenant, that the work that you perform, you both agree, landlord and tenant, is worth X amount of dollars for the time you spend per hour. So if, for example, you agree, look, my time is worth no fewer than $25 an hour or $35 an hour or $50 an hour, depending on your expertise, depending on your skill set, and depending on the agreement between you and your tenant. Either of those numbers might be absolutely appropriate for the kind of things that you're going to be doing to bring the house back up to the condition that was appropriate based on the agreement between you and the tenant. So definitely put in the lease, in the addendum, in the house rules, in the special provision somewhere, an agreement that says you and I agree that any work I perform is worth this amount per hour. Yes, that's perfectly reasonable, and it's something that I encourage. Now, if you know, for example, that a certain task or a certain fee is applicable in the event that the tenant doesn't carry through with their obligation, you can list those things as potential costs, potential deductions from the security deposit, but also as costs that occur during the lease. So for example, if you say, look, the responsibility is on you to cut the grass, but if I got to send Joe's Lawn Care, then I'm going to charge you $75 for Joe's Lawn Care to get out there because that's what I pay, or that's the fee we agree is applicable if I got to take care of your responsibility. Let's say, for example, though, you have cleaning. And let's say that prior to the tenancy, you had Joe's cleaning service. Joe's a popular guy in all of my videos. But Joe's got a cleaning service. And so you hired Joe's cleaning service to come in and make the place immaculate. And along with photographs and video of the condition of the property, which you're always getting before you hand over keys or sign a lease or take that deposit in first month's rent, along with the video and photographic evidence of Joe's work, you also have a receipt from Joe saying that immediately before the tenant took possession, you paid X amount of money to get the house professionally cleaned. You can put in your lease, by the way, we agree that you will return the property in a similar fashion. Same or similar. Same would be you use Joe, you hire Joe, show me the receipt, and move on. You agree, same or similar. If you don't hire Joe, you better make sure that you leave the property in a similar condition as Joe left it before you took possession. So these things are things you can include. And in fact, if you say, look, I paid Joe $350 to make this place shine right before you came in, here's a copy of my receipt. I expect same or similar at the end. And if at the end, they deliver the property to you, and yeah, they vacuumed, and yeah, they kind of cleaned the kitchen, but there's still stuff for you to do, and it certainly is not a similar condition as they receive the property, and your lease says same or similar, and you gave a copy of the receipt and you referred them to Joe and they declined, in that instance, yes, it would be perfectly reasonable for you to say, Joe, I got another one for you. Go ahead and come on in, and then deduct that from the security deposit. These are things that are both strongly encouraged by me, but also perfectly legal when you agree to it in your lease. So next question. All right. If a lease expires during eviction, should I serve a second notice to vacate? The lease specifies rent will be 3 times rent for holdover. So let's make sure we understand what has happened the first time you sent a notice to vacate. So you've got a lease. There's still a little bit of time left on it, but man, your tenant is in default for non-payment of rent. And so you issue a notice to vacate. They don't vacate. And so now you are in the process of an eviction. You have filed the eviction. You're waiting on trial. But wouldn't you know, not only has the lease come to its stated end, the tenant still hasn't left. Are you required to give another notice? Well, this requirement might exist in some other state. I've never heard of that. But I'm going to presume we're talking about the state of Texas, where I am licensed to practice, and I can definitively tell you, no, that notice to vacate already serves as your termination of the whole lease. It is immediate, and it says you no longer have the right to stay here. So the idea that they've held over, again, those rules don't technically apply because you've already terminated the lease. Could you, in a later or separate civil claim, raise these arguments? Sure, and you can leave it up to that judge. But in the state of Texas anyway, you're not allowed to demand all of your contractual damages. In Texas, you're limited to unpaid rent, court costs, and attorney's fees. And so the idea that you might be subject to holdover or damages to the property or accelerated rent, those things all exist. And again, you are allowed to request them in some other civil case, but not in an eviction. Definitely not in the state of Texas. You're limited to unpaid rent, court costs, and attorney's fees. So is it necessary to issue another notice? It is not. The first notice that you've issued is sufficient to carry you through the entire process. The tenant doesn't have additional rights just because they stayed longer. You've terminated the lease. Your burden now is to show proof to your judge, possibly in the trial court, and then again in the second court if you're on an appeal. Your burden is to simply prove from that notice to vacate, since that date, you have had what Texas refers to as a superior right to possession. That doesn't wane, it doesn't fluctuate just because they've been there longer. The only thing that might affect that is if you and the tenant enter into some kind of payment agreement and you waive, the eviction process. But all things otherwise being equal, if you sent the notice to vacate, you filed the eviction, they didn't leave, they haven't paid, and they're still there, you're very likely, assuming you can prove this to the court, you're very likely eligible for your final judgment and ultimately a writ to force that tenant off the property. All right, next question. If the home is under an owner's name, I'm assuming their personal name, but it's managed by an LLC owned by the same owner, will an attorney be needed? Can the LLC assign a daughter, for example, to represent the manager of the manager of the LLC? So we got a lot of questions. I want to take each part separately because each part is important. So you have a home owned by an individual, and that individual set up an LLC, but did not transfer title to the home into the LLC. Okay, well, that's okay. It's probably not the best use of the LLC, but let's say that this is the case. So we're going to call the owner Joe. So Joe owns a house, and Joe has an LLC. We're going to call it 123 LLC. So Joe owns 123 LLC, and 123 LLC manages the property. Now, what we don't know from this question is whether or not Joe's name is featured as a landlord, or 123 LLC is featured as a landlord in the lease, because the outcome would be different. If Joe's name is featured as the LLC, I'm sorry, if Joe's name is featured as the landlord on the lease, can his management company, his authorized agent, present his case in a justice court in the state of Texas, as I explained earlier? If we're talking about non-payment of rent, 100% of those cases can be presented by an authorized agent in a court. And yes, that LLC or a member of the LLC, right? Because an LLC is not a person. So a member of that LLC can appear on behalf of Joe, any authorized agent, in 100% of cases in the justice court when we're talking about non-payment of rent or holdover. Same scenario, except that the eviction is based on the tenant intentionally setting fire to the garage. They did not miss rent, and they have not held over. In that limited case, they have strictly violated the lease by intentionally setting fire to the garage, but only Joe can present that case. Even Joe's authorized agent can't show up for that case, because it's not about rent and it's not about holdover. So let's go on with the question. Can the LLC assign the daughter to represent as a manager of the LLC? Well, that depends. Is the daughter an employee of the LLC? Is the daughter an agent of the LLC, which is an agent of Joe? Again, the same rules are going to apply in the justice court, in the original court. If it's about non-payment of rent, if it's about holdover, 100% of the time, Joe can send his LLC, and the LLC can send their authorized agent on their behalf, right? So it's an agent of an agent. But yes, that's kosher. Not a problem, so long as it has to do with unpaid rent or holdover. Anything else, any non-rent violation outside of those two, you've got technical problems. Now, is the justice of the peace going to catch it 100% of the time? No. But a savvy justice of the peace is going to say, whoa, wait a minute. This violates 24.011. You can't do this. And so I'm not going to allow it. And so, no, get this case out of here, or bring Joe, because only the actual owner, who is the landlord on the lease, can do that. Now, let's go back and say that the LLC is the landlord. Well, if the LLC is a landlord, then absolutely the LLC can do it 100% of the time, right? They can show up, they can send their own employee 100% of the time. Doesn't matter what kind of eviction it is, because the LLC is the stated landlord in the lease. They have much more control even than the owner, who isn't technically listed on the lease. The LLC is better suited in that case to handle 100% of every kind of eviction, no problem. All right, do we have any additional questions? Looks like we've wrapped stuff up. So I've got something that just popped up here. Okay, so that's same or similar question. Okay. Thank you so much, those of you who showed up. If you continue to have questions or continue to say, this guy makes a lot of sense to me, I think I'd like to watch more of his content. We've got over 700 videos here, and we look forward to you checking them out. Any questions you have, continue to leave those in the question or comment section below, because I personally review those, and every single day I'm communicating with landlords out there and a few rowdy tenants, but I'm communicating out there with people who watch our content, and I'm here to be a helpful service. Among those helpful services is our eviction course. And one of the things that I forgot to mention is during the month of October, we're offering a special $100 off that eviction course. So if you are interested in that do-it-yourself Texas eviction course from start to finish, we take you step by step from the notice process all the way to filing, to presentation at trial, and even appeal. If you're interested in that, check it out at attorneyeg.com/EV. The link is down below. And during the month of October, we're giving a scary good deal of $100 off of the course. We look forward to you taking advantage of that. But any questions you have, again, leave those below. Until next time, landlords, thank you so much for joining us live. And as always, happy leasing.